This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
The Dalbert case arose in the early 1990s. Oftentimes, rules and particularly around the admissibility of expert testimony are driven by the kind of case that the court is presented with. In other words, it's not necessarily the philosophical underpinnings of how we understand science or how science and law intersect, but really it's just about often the facts of the case. Are they good facts or bad facts for the plaintiff or the defendant that drives the court? And Dalbert is a great example. In Dalbert, the issue was this drug called Bendectin, which pregnant women had been taking for years. It was an anti-nausea drug. But there was also a potential problem with the drug, which was that some women, when they delivered their children, were delivering children with birth defects. Oftentimes, not always, but oftentimes related to limbs, like a deformed hand or leg. And there was thought that perhaps Bendectin wasn't as safe as Dow Chemical and other pharmaceutical companies had said that it was. And so in Dalbert, the plaintiffs sued the chemical company that made Bendectin and claimed that the drug was dangerous, that it was causing birth defects. The plaintiffs, though, lost all the way up to the U.S. Supreme Court. And the reason they lost was because of the Frye standard. They could not get a court to consider the opinions of their experts. Why? Because the opinion of their experts was a minority opinion. It was not generally accepted, which was the Frye rule. And I'm going to read briefly from Dalbert to give you an example of what we're talking about. The defendants in the case had an expert who had reviewed all the literature on Bendectin, which consisted of more than 30 published articles involving 130,000 patients. And none of those studies had found Bendectin to be capable of causing malformations in fetuses. In other words, Bendectin, at least according to this expert and all the data that the expert had looked at, Bendectin was safe. The plaintiffs in the case didn't necessarily take issue with the published record, but they had 8 experts of their own, all of whom also had impressive credentials. And their experts had concluded that Bendectin could cause birth defects. Their conclusions weren't based, obviously, on the studies that the defendants were using. Their evidence was their opinion was based on in vitro, test tube, and live animal studies which showed a link between bendectin and malformations in children. What's interesting about this case and where I started out is the facts are really compelling. Children were being born with significant birth defects, and there was at least some legitimate evidence that bendectin was the cause. Was it the majority opinion? No, it was not. And as Chris said, consider where the majority opinion was coming from. It was coming from big pharmaceutical companies that had hired experts to study their product to determine if their product was safe. Their product was making them a ton of money. And up against that was this minority opinion. But those are compelling facts. We're talking about children born with birth defects. As I said, the plaintiffs lost all the way up to the Supreme Court. By the time the case got to the Supreme Court, though, the federal rules of evidence, Rule 702, had been adopted. And that rule, as we're going to get to in a minute, changed the landscape of the admissibility of expert testimony. What the Supreme Court did in Dalbert, though, was agree essentially with the adoption of Rule 702 and then determine that Rule 702 would have allowed for the plaintiffs to introduce the minority expert opinion in their case. It didn't mean they won, because a fact finder would have to determine, which side it credited, the defendant's experts, being the pharmaceutical company, or the minority experts for the plaintiffs. But what Dalbert did do is said, we're going to change the general acceptance Fry test. And we're going to, and this, let me pause here. This is the way I explain Dalbert to my students. I think Chris and I interpret it or talk about it slightly differently. But the way I think about it is the U.S. Supreme Court in Dalbert expanded the ability of courts to admit expert testimony. In other words, no longer were courts only admitting generally accepted expert opinion, which is what Fry said. Courts were now saying, no, we will broaden the standards for admissibility to include even minority positions which may not yet be generally accepted. To go back to something Ira said, because science is dynamic, it moves forward. The minority study today, the minority opinion today, may be tomorrow's majority opinion. That's how science works oftentimes. And we're not going to preclude that minority opinion from being considered by the fact finder. In that way, Dalbert, at least the way I conceive of it, expanded the ability for the admissibility of expert testimony. However, the court also, consistent with Rule 702, said, but wait a minute, there are standards. It's not a free-for-all. It's not any opinion, no matter what comes in. No. There are standards. And if you look at the slide, there are 5 standards listed here, but these standards are not necessarily exhaustive. And I think one of the things you'll sort of notice about them, intuit about them, is in some ways they are the components of what we understand to be sound science. So majority opinions can come in, minority expert opinions come in, but if and only if the theory or technique in question has been tested, whether it has been subjected to peer review and publication, whether we know its error rate, whether we know and can articulate the existence of controlled standards for how it was tested, and whether it has attracted widespread acceptance within a relevant scientific community, something Chris has already talked about. These, again, are a non-exhaustive list of standards, but and the reason I'm non-exhaustive is because A, they're non-exhaustive, but B, various disciplines have different standards. But generally speaking, these are sort of the touchstones of whether or not a particular discipline or expert's opinion is deemed trustworthy enough, reliable enough to be admitted consistent with Rule 702 in Dalbert. So I hope my conception of it anyway is A, not completely wrong, I don't think it is, but B, that it makes some sense, which is we've moved away from Fry to a broader acceptance, and to in large part driven, I think, by the compelling facts of Dalbert. Birth defects in fetuses, in newborns. That's compelling. And the court felt like, we should admit this type of evidence, not because the plaintiff is necessarily going to win, is going to prevail, but because fact finders should at least be able to hear and consider this minority opinion, which meets Rule 702 in Dalbert, meets some of those standards, or all of them.
I don't disagree with well, I do disagree actually with Tucker, but there's plenty of support for Tucker's interpretation of Dalbert in terms of it being more accepting of a broader range of purportedly scientific opinions. And certainly it says that in the opinion itself, that, and you'll see a lot of courts seizing on the flexibility language of the standard to admit almost anything. So in my view, and perhaps a minority view amongst legal scholars, is that the standard itself is, if it's rigorously applied, or even, with fidelity to real science applied, it would exclude much of what actually gets into court, as a practical matter, because this is very judges were before supposed to be deferring to the scientific community. And what this opinion changed was that the judges were now acting as gatekeepers, right? So it was their role to basically learn the science, right? To know whether or not that the technique had been tested, and whether or not, the peer review and its error rates and all of these elements. The court charged the courts with excluding that type of evidence. And that hadn't been the case before. It had been deferring to what scientists says. And a lot of mischief could be made with that standard, because how you define the relevant community, as we talked about before. So I think that Tucker is correct. And certainly in the way that the opinion reads, but as a practical matter, I think that the standard is actually a much better standard. It just needs to be applied in a rigorous way. The Dalbert opinion was really three opinions. There was the Dalbert opinion, there was Kumho-Tyre, and there was a case called General Electric v. Joyner. And basically these trio of cases changed the federal landscape and then ultimately state landscape on the introduction of scientific expert testimony and just regular expert testimony. So Kumho-Tyre was the case that followed Dalbert to the Supreme Court. And that was technical expertise about, I think it was the air pressure in a particular tire, or was the recommend. I can't remember exactly what it was about the tire at issue, but the expert testimony wasn't necessarily scientific testimony, right? So it's very, very difficult to say what's scientific experts, or what's scientific and what's just technical expertise. Right? Is crime scene reconstruction, is that scientific evidence or not? Right? Is it, it's very, very hard to say, right? And then there's always been this kind of exception, through the case law for a lot of the techniques that have been introduced as scientific evidence, but have not been subject to really any standards, essentially because the courts have looked at those techniques like fingerprints and bite marks and tire tread evidence, and said that this is really not complicated stuff. This isn't the kind of science we were talking about, and you don't have to know all of these error rates and all the rest of for Dalbert. They've kind of excluded that from real scrutiny, some of the worst, purportedly scientific evidence that's been introduced. Kumho-Tyre says that we're not going to make this distinction, and that between science and technical expertise, the same list of factors, the same non-exhaustive list of factors that we listed in Dalbert are relevant when you're talking about just any expert witness testimony. You're going to have to be flexible with the way that you judge whether that's sufficiently reliable to be introduced in court. But this applies to non-scientific expert witness testimony as well. And I put that there because, this distinction, I think, is still playing out in American courts and still not getting it right in many circumstances. But theoretically, Kumho-Tyre should preclude, or at least create more of a barrier to entry for some of these techniques that can't pronounce an error rate, that haven't been tested, that haven't been subject to real peer review, but the courts haven't been imposing it that way. So the third case in the trilogy is basically setting the standard for an erroneous admission of expert witness testimony. So if somebody gets convicted or loses a civil judgment and they say that they're appealing that judgment, the court said that that's an abuse of discretion standard, right? So the only way that you can get the judgment reversed is if that the court finds that there was an abuse of discretion for admitting that evidence, which is a very high bar to get anything overturned. So it really made the judgment at the trial level, really, it's not going to be overturned unless it's really outrageous. So those three cases all set the standard. And just to be clear is that when the Supreme Court decided this, they have no authority over the state courts in terms of, or states at all, in terms of their evidentiary standards. The only thing that they could say was that this is for federal courts, and then it's up to Congress to legislate, federal rules of evidence. And those only apply in federal court. Now we're going to talk a little bit later about the influence of that in state courts, but just to be clear, we're talking about two separate systems, federal and state. And in federal court, all this is the law of the land. States can take what parts of it they want, what parts of it they don't want.